Good evening, everyone. Welcome to the new season of Belgrade Legal Theory Group meetings. The opening session for this academic year is dedicated to very interesting topic and very interesting lecturer. Topic of this meeting is social-legal theory, and our lecturer for today is Mr. Damir Banović. Damir Banović is Senior Teaching Assistant at the Law Faculty, University of Sarajevo, at the Department of the Theory of State and Law. And his most prominent work is the political system of Bosnia and Herzegovina. But for me, the most interesting fact about him is that he is a member of the European Commission on Sexual Orientation Law. But today he will talk about other aspects of his work, which was his topic for PhD thesis, and that is the strengths and weaknesses of social legal theory. So, Damir, the floor is yours.
Thank you very much, Mila, and thanks others for inviting me. It's always a pleasure to be in Belgrade, even though virtually. I had always a great time and always a great discussion, no matter which topic is. It's actually my great honor to have to start talking about something which is of my main interest, is actually social legal theory as a new way of understanding and researching law, specifically more concrete theoretically to research. And Ban also proposed to have this mix of, in sense, what are the weaknesses and what are the strengths of social legal theory, which is actually very important to emphasize both sides in order to find the best way to talk about law and also to theorize about law. I have prepared a PowerPoint presentation, so you can easily so to say, follow my chain of thought. Sometimes I lose myself. That's why it's probably more easily to somehow follow through presentation. Of course, I'm not going to talk about all the weaknesses and all the advantages of the social legal theory, but I actually have chosen a couple of them. First of all, I'm going to start with the weaknesses. For my PhD, I've seen that there are, for example, when we talk about social legal theory, we're not talking about one theory or one method. Actually, we're talking about different methods and different approaches within the legal theory when it comes to being, so to say, inspired by something which is empirical research. So that's one of the problems. So different names and possibly different methodologies for one discipline. This is actually very problematic. Do we actually talk about one discipline? Second is, which is I think very important, is there a clear methodological distinction between sociology of law, social legal theory, and is there a need? Three, acknowledgement among theorists as a legitimate method. So there is still, I wouldn't say that there is a debate among the theorists that this is a legitimate and non-legitimate, but actually, I don't think that there is they pay much attention towards these possibilities within the social legal method. Of course, there are need for further theoretical improvements. Maybe we have, I don't know, since 30 years, something which is social legal theory within the theory of legal positivism. And fifth problem, it's actually that depends on empirical research. So if we don't have empirical research, it can be problematic actually to get this inspiration for theoretical improvements. For example, what do we consider this broader branch of social legal theory? For example, we understand we can possibly understand, or different authors actually understand it as a legal realism, sociological jurisprudence, critical legal studies, economy and law, social legal theory as a now specific branch within the legal positivism, law and the society. For example, when we talk about, for example, critical legal studies, economy and law, they usually go outside of the law as we understand as lawyers, while, for example, legal realism, sociological jurisprudence actually criticize legal positivism, but within the theory of law. So actually, what comes under the branch social-legal theories, there are like criticism or different ways within the legal theory, but also outside of the legal theory. For example, critical legal studies actually come outside when they understand, for example, law as an ideology or a power, or the for example, racial theories or queer theories. Actually, they come usually outside of the legal theory, which we understand, for example, Hartian legal theory or Kelsen legal theory. So this is one of the possible weaknesses. In sense, there is a lot of branches, I would say, within what is considered social legal theory. Of course, we have different authors. For example, within the legal realism, there are different authors and different methodologies. For example, Roscoe Powell, Benjamin Cardozo, Underhill, Jerome Frank, Oliver Wendell Holmes, they all had different, I would say, methodologies when criticizing and theorizing about law. How I understand what's social legal theory is something within the branch of legal theory. Second is understand law as we understand it. And the most prominent actually authors in contemporary are, for example, Brian Tamanagh, Dennis Gallagher, William Twining, Roger Cotterell, Reza Banakar, and the others. Second problem is actually, is there a distinction between sociology of law and the social legal theory? This can be also possible weakness, but also understand this. It's very also important to differentiate these two approaches: sociology of law as a branch of sociology, which how I understand it, and social legal theory as a branch of legal theory. Is there a possibility? I was also doing this research in this topic. Is this a possibility, for example, to create something and methodologically theorize about the law within the tradition of legal positivism? You probably know that, for example, that Hart was using Weber to create his concept of law. And of course, if he had used it to simplify it, we also can start it from the Hart's concept of law. We can create something which is sociology, socio-legal theory, or to improve methods already developed within the Hartian system of primary and secondary norms. So first, the problem or the weakness is actually there are too many different ways of researching, and which comes under the umbrella of social legal theory, but also within the social legal theory as a branch of legal theory, there are different ways of theorizing. So we can't actually talk about one unified method or one unified way, which can be actually put under the umbrella of social legal theory. I'm gonna leave other weaknesses maybe for discussion. For example, this need for the empirical research and this need for the further in developments. We can talk about later. What are the possible strengths? And I truly believe these are the strengths. First, I think it's a true general theory of law, which comes out from this concept of the folk or the national system. You're aware that one of the, I would say, main problems of the legal theory, it's usually concentrated on the national systems, so systems of national state. But the social legal theory, in the way, for example, in Brian Tamanagh, actually helps us to come out from the national system and see if we can recognize and see, are there any other normative system outside? Second is, I think this is one of the advantages, non-essentialist approach. Third is a legal theory, a social legal theory, sorry, is a heuristic model to better understand other normative and law-alike systems, for example, transnational law, customary law, arbitration law, etc., which doesn't have all the necessary qualities which usually national legal system has. Fourth, helps to understand sources of law in one legal system. I'm going to talk more about this. And fifth, improves our understanding on how law interacts with the social context. This is something borrowed from the Professor Galligan, contextual deliberation of norms. I'm going to talk about the fourth and the first question more, or what I would say like strengths or the advantages of social legal theory. So, sources of law. Why I think social legal theory is also better way to understand what are the real sources of law in one legal system. I was doing one research on for an encyclopedia. So it was a comparative constitutional law, and one of the topics I had to do research is on the law. So how the law has been seen in different jurisdictions, from I don't know, from the Saudi Arabia to China, Bosnia Herzegovina, Serbia, etc., and how we understand sources. So sources, this is a question for the first year. It's actually the way in which, if we talk about formal sources, is the way in which a law actually appears to us. So what the formal sources include or can include: legal norms directly proclaimed by the public authority as a general law or special decrees. Second, legal norms derived from the general practice of social groups, customs that the authority takes over and gives them the power of a source of a law. And judicial practice that creates rules for resolution of a specific case. This is something quite normal, or I would say general accepted sources of law. So what's where do we have a problem? So when we come to a comparative law perspective, Wagner says that in a given legal system, the law doesn't simply consist of raw legal sources. So when we research law comparatively, we can't say that formal sources or formally established sources of law, they're not the only sources of law in that legal system. And actually, what social legal theory actually can help us is to see which sources of law are acknowledged, not just only the formal ones, but only, I would say, the substantial ones, or the sources which, for example, court takes into account when delivering a case, even though that's not formally recognized source. A second, which I also believe that can help, actually this answer can be, answer to this question can be given by the socio-legal theories, which methodological approaches prevail in the various legal systems. So distinctive mode of legal thinking, historical development, etc. And when we talk about a comparative perspective, we have to answer these questions. And these questions can't be answered only based on the formal sources. So who creates law, how it's created, which factors are taken into account when doing so, what are the products of the law-making process, and which documents can they be ascertained. So if we're doing a research, not just only applying a law, this socio-legal theory, which with its non-essentialist approach, and this understanding a law as a convention or labeling something practice as a law, can actually helps us to discover which are not only formal sources, but only the sources which are not formally recognized in that legal system. I'm not going to go through this. I can give you a PowerPoint presentation. So how can we actually further develop sources of law when we go comparatively? But actually, what also social legal theory gives us as opportunity to better understand what are the sources. And I'm going to talk. This is going to be my last part. I'm not going to talk too much. I think this is a true general theory of law. Why do I think so? Because it, not only in a application side, but also in a research side position, it I would say doesn't burden us with the prejudices of what elements law should have in one legal system. So if I'm coming from one state to another, I'm not gonna have my conceptual apparatus with me, but I'm gonna go completely tabula rasa in that legal system and then try to find elements which convey under, or actually can put under the umbrella label law. But of course, we're gonna also definitely probably find the same elements as we have, for example, state law. So why do I, so for example, Taman had distinguished these two conventional recognition of law. I'm going to start with a his simple sentence. He says, the law is what we consider as law, or what we put a label on something as law. It's a very thin definition. It's actually not even a definition. So it's too broad. But it's actually, it's not supposed to be definition, but it's actually supposed to so say liberate us from the concepts which we have, for example, in a modern legal systems. So when he says, for example, what can be labeled as law? First can be labeled, so first category is based on conventional recognition of the pile of law through actions of participants. So first understanding of law can be, okay, participants which are within the legal system recognize something as law. A second category is based on abstract characteristics. This is something that theorists usually do. So they try to find elements in order to create a concept. So this first category starts at conventionalist interpretation of law. So actually, if I'm going outside and walking and someone says, this is illegal, but maybe this is not a part of a legal system, maybe that's part of customer, or this is rude. So someone labels some action as law or lawful. For example, state official would say this is a constitutional, and that official also labels some action as a law. And this other part is directed at interest, at the needs of theoreticians for localization of fundamental characteristics. So when we have something which is labeled as regulation, then we can try to say, this way of behaving, we can actually put, or this way of regulating things, we can put under umbrella state law, which usually has like this unity of primary secondary norms, but also there are some other forms of regulation within that society. So the first category is related to a set of categories that contain the conventionalist recognition of the piles of law. That's why we discuss state law, religious law, natural law, common law. For example, you can see only one category is state law, which usually has characteristics given us, for example, from Kelsen and Hart, this legal positivistic tradition, but also recognize some other forms of regulation, for example, religious law, natural law, common law. And why is this important for us? It's important for us because sometimes in one judiciary or intuitively saying, court can use natural law in order to solve some case, or natural law can affect when interpreting norm of state law. And I think this is very important to have these distinctions, that there's not only one regulative system as a state law, but there are also different kinds of other. And what actually connects them all, not some specific necessary characteristics, but they have the same recognition. What does this mean? So one social group recognizes that as a way of regulating behavior within the social, or Amish group, or some Muslim groups, Catholic group, or supranational law, transnational law, arbitration law, etc. So someone has put a label on it as a law. For example, Professor Miodrag was writing about the transnational law, when something which we usually don't understand as law, this is the bylaw of one non-governmental organization, was used as a way of regulating, for example, anti-doping activities in Olympic Games, actually regulating very important aspect of sports life. And the second category, why is this is more an application part. This second category, which is important, is actually this complex of mutual fundamental characteristics abstract from phenomena that is conventionally recognized as law. So our actual tasks as theoreticians is actually to find mutual characteristics. So religious law, customary law, law of the organization, but also to recognize something as a state law, which usually has characteristics already defined, for example, by Hart or Kelsen. But and how we actually do this is actually after abstract, and we formulate these characteristics only after the study different social practices and phenomena that are conventionally recognized as law. So this non-essentialist approach, I think, is very important. Usually we would say, okay, law has some kind of functions or has some necessary characteristics, but social legal theory says, no, it doesn't have necessary characteristics. Why is this important? Because it does. We would usually say, for example, that law prefers some functions, usually meaning under this umbrella state law. But for example, we can come, for example, in Bosnia and Herzegovina, and you can see that actually the state law doesn't perform the function which usually are conceived that should be performed by the law, but actually some other regulations, some other practices are recognized as the way of regulated behavior among the politicians, within the parliament, within the government, etc. And of course, this is usually the way how we further, like, logically try to find elements which can or we try to form typologies or concepts in order to better understand. And of course, we're going to come probably to the concept of state law. And this is I wouldn't say this is one of the conclusions, that there will be no concept of definition of law as such. Probably we will come to the similar conceptions, maybe different conceptions, but the idea is not to have this prejudice that the law has some necessary functions or some necessary characteristics. This is actually the one of the, this is actually a heuristic model or the methodological way, just to have not to have any prejudices or to come as tabula rasa when coming to, for example, one national system and seeing, these are the sources of law, these are the formal sources, these are the substantial sources, these are different ways of regulating, etc. And why this is one of the, I would say, weaknesses, but actually possibilities of combine. I wouldn't say combining, because I don't see this as interdisciplinary work, because interdisciplinary work means combining different methods, but actually empirical research can help us in order to establish maybe new concepts or to change concepts which we already have. For example, you're very well, I mean, it's probably well known for you that administrative law in many Western countries often includes balancing between interest and instrumental consideration for the needs of achieving certain policies. And it obviously does not enter the description of law as institutional application of principles or law as a system of primary, secondary legal rules. So there is something more, usually from the side of primary rules, that is not only defined within the formal sources. So there is more, something more. Usually you would say your students will, when they graduate from faculty, usually they would say, but this is so different when you come to court, or when you come to prosecutor's office, or when you come to the work as a solicitor, because there are some other regulations which actually affect either the interpretation of law. There are some other informal sources which are used in order to deliver some kind of some decision. And what's actually one of the I would say advantages of this, I don't know in which context I would put, that this approach does not give a hierarchical status to a certain version of law, which is often given to the state law. So usually state law is positioned from the power, this is the only source of law. But this socio-legal theory, or different approaches within the socio-legal theory, actually tells us that the state law is not the only law which regulates the behavior within the society. So the idea is that usually when we talk about law, we usually consider state law. But the idea of socio-legal theory is actually to broaden this perspective and to label different actions as law. And from all of this spectrum to see, this can be under the branch of state law, this can be a branch, for example, customary law. And of course, this comes and how actually social context actually infects something which is law, sources of law, or interpretation, or determining how to actually we have the application of law. And one of the actually main strengths, I would say, that there's no preliminary assumption have been made with respect to normative significance of certain type of law, efficiency, or functionality. If you do research with different branches, criminal law, maybe civil law, you see that there is a law in sense of state law, but maybe it's not efficient anymore. So we don't make any assumption when it comes, is this a functional law? Doesn't actually perform some kind of functions within the society, or is it efficient? The idea is actually come and research, do an empirical search, and then you'll see, is this law efficient or is not efficient within that society. Okay, and what I see, and one of the weaknesses within the social legal theory is actually, this is more or less Tamanahas's approach, but you also have Galligan's approach, Cotter's approach, Reza Banakar's approach. So they have different approaches within the, I would say, contemporary social legal theory. So if we actually move the sociological jurisprudence, legal realism, critical legal studies, this is one of the weaknesses within the social legal theory sector, that we have different ways of understanding how can we improve legal positive theory or Hartian method in order to give more scientific approach, or to give something which is more empirical research, or influence of empirical research in theorizing about law, but from the legal theory point of view. And one of the, I think, very important parts is like withdrawal from defining the content of law is a significant step towards letting go of essential conceptions that predominated the recognition of what law actually is. This is the non-essentialist approach. So law doesn't have an essence, in sense, meaning that we can't come in one national system and say, these are necessary characteristics of law. If you don't have these characteristics, ergo, there is no law. But then we see there are different kinds of regulation in the system functioning, but we can't find these necessary characteristics, which we usually have from the legal positivistic approach. And this actually helps us to be more general theory of law, not actually being based on a national system. I'm gonna leave it here and just go through these 3 points. Why is this significant? It's significant. One of the reasons is because preserving the form in which law appears in a specific social context. So it doesn't appear only as throughout the formal sources, but also from other sources. There is some kind of relationship or mutual relationship between the social context and the law, and also creates possibilities for critical evaluation of one of the multiple forms of law. So actually, to put it simple, I would say the idea is, and one of the strengths is actually to start, and other researchers have already done it, to start from the Hartian method and to improve this theoretical method in order to have, I would say, a theory which is inspired by something which is empirical research, in order to better understand what law is, if nothing less than just to be aware there's something more going on in one national legal system or in a supranational legal system, or for example transnational law, is a perfect example of how something which is not understood as a formal source of law interacts and comes within the legal system. Of course, this is how to actually to have this structure stable is always secondary norms actually helps us to have this structure and say, some court has recognized as something as a source of law, even though it's not a formal source of law, in order to apply it in concrete case. I hope I have managed to simplify this as much as possible, even though it's very hard because as I already told, there's no one theory, there's no one social legal theory. That's actually one of the problems. So there are different approaches when it comes to just stop this sharing. And then when if you want to criticize and if you want to see what kind of problems actually, you go to one author or one perspective within this social legal theory. Thank you very much.
Thank you, Damir. Now is time for a discussion and for the questions. So, do we have any question? You can type the question in the chat, or you can ask for a question like Sava just did. So, Sava, here you are.
Yeah, thank you, Damir, for the excellent presentation. It's quite a wide topic, and I see you focus just on a few primary points. I definitely agree with the starting premises of the social legal theory and the actual conclusion that normative arguments and a priori conceptual analysis, which are focused on the essence of law, definitely are something which is quite debatable and have their weaknesses, obvious weaknesses. But what I'm interested in is actually what would the empirical methods of inquiry look like in practice, or how would we actually provide some sort of inquiry into the, as we all know, complex phenomenon of law, which includes also the psychological processes and the complexity of our human existence, all in all. Which means that if we use the Hartian terminology and say that there's also the internal aspect as well as the external one, how would actually that process look like? Could you give some sort of an example from something that would combine these methods and rely also on research findings from psychology and sociology, and just to make it more concrete? Thank you.
Thank you very much, Sava. One of the problems is actually that this is actually opportunity, but also a problem, in the sense that we don't do empirical research. That's actually one of the problems. But actually, we only take something from the empirical research which actually can help us. So that can be some multidisciplinary teams in order. Okay, I want to see internal aspects. So Hart says internal aspects, why it's important, and says it's important, but this is actually a starting point from which you can start empirical research. Probably, we're not going to do this empirical research. Someone else is going to do it, who is more into sociology or law, empirical research, etc. Then he can or she can conduct research, for example, within the court to see, or within the parliament to see what they understand as principle of validity. So if you say a principle of validity is something which is internal part, so we accept something as a law, we can go and do research in sense, okay, go parliament, go, for example, if we're talking about secondary norms of education, go to the court and see what the court says, what the law is. And if it confirms what we already have within the concept of law, that's even better. So now our concept of law is actually on a firm basis, I would say. if it says we're using some other sources, this is also very important. So, okay, we have formal sources. I'm simplifying. We have formal sources, but we are also using this and this and this when educating cases. And then I think we can, as a researcher, maybe not as application of law, because maybe this could be illegal. We can say, okay, when educating, when having a case before your court, he takes also these facts into consideration when delivering a case. And this is something which can be done. For example, cantonal court, you can go through the judges and then say, what do you accept as law? And this case of transnational law, for example, this Supreme Court, I think it's the Supreme Court of Switzerland, recognized recognized bylaw of one non-governmental organization as law. You can say, I mean, from the point of maybe this traditional concept, this could be weird, because how do you use this as a when delivering a case, or in something which we don't consider as a formal source? But then this fact or this knowledge or this awareness of something can be used as a different, actually helps us to maybe change our concept of I would say formal sources of law. It can be, I mean, simply put, it can be two ways. One way, it can confirm our concept of law, of state law, for example, in Switzerland, Bosnia and Herzegovina, and Serbia. But also it can say, in this national system, internal aspect is something different, or external aspect is something different. So people behave differently in different cases. And this can be also like case by case national law, but also in a wider perspective. I hope I'm. But this is one of the problems within, because we learn law, state law, of course. We also theorizing about law, state law, of course, but we don't have enough education, maybe not enough time to go through empirical research. So we need this help from the, I mean, I would say sociology of law, in order to establish, okay, this is the ideology of the constitutional court. This is something, or if they use some material which are not considered usually as sources of law, or within our understanding of what source is, then actually can help us to improve or change our concept of law, maybe within one national state or etc. Yeah.
Another question is from Duška Franeta. Duška, floor is yours.
Thank you. Damir, thank you for the excellent lecture. Do you hear me?
Yeah.
Yes? Yeah. Well, your lecture was general, and my question will also be pretty general. And it is, how is it possible from this perspective to distinguish between better and worse law or legal system, or however we term that? You said pile or phenomenon or whatever.
Basically, you can't. You just see what the practice is. When I was writing one article, the idea was like to see what law is, to confirm it empirically, but then we have some kind of normative standards, and then we criticize it based on this. We can't, in how I see it, you can't criticize from this perspective. So you have to have some kind of normative standards from which you evaluate if this is a good law or bad law. So this method doesn't help you, at least this part, doesn't help you in order to evaluate, is this a good law or a bad law? This is only to see what the law is, in a sense, in the most general abstract way. And then, of course, some authors have said, okay, we're going to improve Hartian method in order to better understand what are, I would say, like regulatory systems. But then the third step, I would say, there's normative standards from which we can criticize what the law is. Because if we don't know different kind of regulations or different kind of labeling what the law is, we can't also criticize this. So we have to be, so if we only focus on state law, but state law doesn't apply maybe in some cases, so something different applies, or certain practices applies, we can also label as law, or maybe not, then we can't also criticize. So to have a clearer picture, first we have to like clean the space of what is law or what the state law is, or what forms of law-like phenomena we have, and then from this point we can criticize. But this method doesn't help you in this. I don't see it. So.
If I can make a follow-up, so you see it as a method, just one method. Am I right? Not as a full perspective. No. Okay,
No,
thank you.
This is only this is only one of the way of understanding.
That's clear. Thanks.
This is only one way. I don't see. I mean, some authors were combining like, okay, we're gonna have also this normative. I mean, like in a sense of holistic approach, but it's. I think you should go step by step in order. This step is more into a sense of seeing what are the real of regulation, what are regulations, but then adding also this normative evaluation that would be too much for one method. It's like too much for one method to combine all of these perspectives. For example, from Mauro, Nikola Viskovic was thinking, okay, we can have integrative theory of law, but I'm not so really sure that's possible. I mean, you can add this normative evaluation, but this actual method, actually one way of seeing law doesn't give you this opportunity.
The third question is from Damir Pavlović. There, the floor is yours.
Can you hear me?
Yes.
Yes, cool. Well, thank you for a very interesting lecture, Damir. Well, I had some problem. I guess I believe that you had a few as well, so it will not be against you. First of all, I totally acknowledge the need for contextualization of law and the impact it may have, but some of the arguments and examples you have provided for me, I could not buy them. First of all, even positive law recognize delegation, for example. So your example with FIFA or VADA or whatever, delegation solves it. Autonomno pravo, however, it's translated in English, I'm not sure. Furthermore, similar to what Duška asked, I could not distinguish between what is legal and what is illegal if we are only seeking the question how the law is being applied. Suddenly, nothing is contra legem. And Hart provides us enough of this sociological, what happens and what is valid. So that's my major concern. I think that all the answers have been already provided by two leading legal conceptions. And I was also, well, the third point you mentioned at some point that even hierarchy is not something which is untouchable. You say, I'm not relying on the hierarchy. I will just seek to see in reality who has more impact. That's in contrast with legal certainty imperative. So too many flaws for me to bite. Thank you.
Okay. How to answer? Maybe we are. I mean, you said also that Hart has answered. I mean, yes, definitely he answered some questions, but we also have to consider which legal system he took into account when talking about, and which. I mean, for example, Galligan says about I take into account only democratic Western European countries, and I think we are sometimes parochial in sense. Okay, this is our legal system. This is Hartian, but let's try and to apply this concept in some other national system. For example, China. Let's go to China and see it, or let's go to Saudi Arabia and see what the law is. And this is why I think that we are sometimes when we talk about, we usually see Western European countries. So I mean, Kelsen also was a European. Hart was taking into account, I mean, usually English law, and this concept what we can find within the English law, and then create concept of law, which possibly can be also applied within the other I mean, we don't know. Maybe it has this characteristic or not. So this is true that there's some part when actually state law gives maybe this administrative law. This idea maybe wasn't the best example. But I think I was doing this comparative research on maybe 200 constitutions, and to see how they first concept validity, or do they concept formal sources. More or less all of them have something which is a concept of validity. So you have this formal criteria. But for example, if you go to Saudi Arabia, do they really have all this concept of validity as written within the constitution? Or when educating some cases, do they always take something into account which is formal sources? I wouldn't say that we were going to abandon it, but the idea of this, how I see it, is not to be burdened, but already created concepts. In a sense, okay, Hart gave us this unity of primary and secondary rules. Maybe this is enough. Okay, we have primary rules, which is actually how we regulate the behavior. Secondary rules are actually rule of recognition, education, and change. But I don't think that this. Maybe in some jurisdictions you will see, for example, religious law will be one of the sources. Then you can actually see this connection between the rule of recognition and this other norm who actually recognize this as a source of law. But in some jurisdictions, maybe you're not going to see it. And if you actually prove this is true, even better for the legal positivism conception. If you see that there's something different, so yeah. But I don't see how I understand this concept of we're going to label everything as a law. This is a very complicated. This is very not complicated. This is very. This is not even a definition. So labeling every practice as law. But I think, as I already mentioned, this is a heuristic model. So it's not even it's not a methodology, but it's actually to open up space of some other regulation, which can be maybe in some other jurisdictions, which are not maybe European, or maybe in some other countries. This is actually the way to open up a space on something which is not only European or democratic states. And I mean, this citation I used from comparative law perspective, actually, they say that we can't rely only on the formal sources, but we have to rely on something what people understand, or not only not laymen, but people who are civil servants actually understand that as a law. And then we actually maybe through secondary rules with this accept as a state law. So I wouldn't say that it radically changes, but actually broaden perspective and opens up eyes, in a sense, not to be too essentialist about the concept of law. Maybe at the end it's going to prove that this is the same as the European countries, but this is also good for us to see, okay, this can be really a general theory of law, but not parochial, related to some national system. Yeah, I hope I understand. Yeah. I mean, there are some problems within this approach, but I would say if we somehow neglect this too broad definition, I mean, this Newtonian definition, but when we come to national system and go through empirical research and see what the concept is, then we can, actually, it doesn't, maybe from the research perspective, so scientific perspective, we're not going to label something as against law or a contra legem, pro legem. But for example, when applying law, we're going to see this as this is against the state law. So this is two ways of research. One is more research level, and second is more when you apply actually state law in a concrete case. but there's still to do on this, so that's why I should work on this more. So yeah, there are some flaws, of course, because it's too thin. That's definitely. But I would say, for example, Dennis Gallagher says about social spheres. I think the social spheres are also important. For example, if you come to court or prosecutor's office, I think this some regulations which are not maybe recognized by the state as a valid source can affect your particular case. So this is only the like, not to be blind. This is only one way or two ways of solving the case.
Anna is next. Anna, you may ask your question.
Thank you, Mila, and thank you, Damir. This was really informative for us that do not have tight connections with either sociology of law or social legal theory. But I wanted to shortly comment that this approach is quite appealing to me, especially if it is understood from the perspective of international law. And I would say that this essentialist approach is the one to blame for the whole controversy of international law being questioned whether it is law or not. So basically, I would like to emphasize that is, from my perspective, the best example how this non-essentialist approach should be utilized, and how we should not start the research from already having some kind of theses and characteristics. And I think that Jovanović showed that in the book you mentioned. So basically, considering that something, the system called international law, does not satisfy the characteristics that are laid down by the state law, doesn't necessarily lead to the conclusion that it is not a law by itself. And finally, he also challenged the fact that it is questionable whether the state law satisfies these characteristics itself. So yeah, that's for me. Thank you.
Yeah, that's also one. I would say non-essentialist approach it's a good way not to burden yourself in the sense of already created concept of state law, and to see, for example, in the international, is this a law or not law. So the main idea is, okay, we're going to label it a law, and then we're going to see what characteristics it has. I would say like empirical research, and then see what characteristics does it have. Maybe some different characteristics, but we're not gonna say, this is not law, but we're gonna differentiate. This is state law, and this is international law, which has some specific characteristics. This is state law with specific characteristics, but it's a law in sense of regulating some behavior. I mean, it's a broader definition, I would say. Yeah, but actually it helps. I mean, Dan, sorry, I mentioned also VADA. But I mean, VADA, I mean, court recognized this as a source. So that's how we kept this idea of unitary. So like structure, we have a structure in a sense. Okay, some court said this is a source of law. So we kept this structure, which actually provided from Kelsen or Hart. But the source is problematic, I would say. So the source is problematic in the sense, I mean, non-governmental organization regulating something. How can this be a source of law? So one part we have, it's like it complies with like this traditional concept, but this source, it doesn't comply. So this is, and the traditional theory can't answer this.
Thank you, Damir. Since we don't have any more questions, I have the last one about the relationship between Max Weber and Herbert Hart, and the impact that Max Weber had on Hart. So can you tell us something more about that in short?
I mean, this is more of I think also Weberian method was not really a sociological in this kind of terms, but it's also very intuitive and analytical. And he was also using this, I mean, you probably know, I don't know if this is also a lie, but yeah, gossip that actually Hart thoroughly read Weber's work. And actually, if you read Economy and Society, I think that's translation in English, you can actually see all of these levels, how you actually create norms from convention, from like basic regulation to conventional base. And then he actually used this conventional way and then recognition, this internal point of view, external point of view, which were developed in the Weberian work, in order to create analytical framework for his concept of law. I'll to be more thorough with the answer, I will have to go through again. But basic ideas actually were taken from the Weber, and then but he never cited any of his work that's I would say like public how to say, like secret. But you can find this elements of external, especially external, internal point of view, how we actually create convention. So you can see this, I would say, influence on his. So if from Weber to Hart, then we can go from Hart to socio-legal theory. Yeah.
Thank you, Damir, very much. Do we have any more questions in these last minutes? No. So thank you all very much. This was great opening of this new academic year. So Damir, we hope to see you not just virtually, but physically in Belgrade soon. Thank you very much. Stay safe and see you soon on the next meeting.
Thank you also for inviting me, and see you. Bye-bye.
See you all next Monday at 5.
See you.
Bye.
Bye-bye.